Well, hi, everyone, and welcome to today's edition of the Zoom immigration meeting. And my name is Mike Sherman. The name of the law firm is Sherman Immigration, PLLC. And thank you all for joining us today. Here in Michigan, it's very cold and snowy, and hopefully some of you are in warmer climates, and maybe you can send some warm weather our way. But the meeting today is focusing on marriage-based green cards. And so today we're going to discuss all kinds of information, questions regarding the green card process based on marriage to a U.S. citizen and also marriage to a person who has a green card. Among the questions we'll be talking about, and this is kind of on a lighter note, is what color is your spouse's toothbrush? Now, sounds like kind of a silly question, but as we go on, you'll see the relevance of it a little bit later on. So something to keep in mind. I actually do know the color of my spouse's toothbrush, but it's something for every applicant to know, and I'll explain why in just a little bit. But first of all, I'd like to thank Carolyn Taylor, my wonderful legal assistant, for all of her help in putting today's presentation together, and also to thank Jeff Bumbales for all of his technical support today as well. So thank you again for joining us. If you have questions as we go along, please feel free to put them in the chat box, and then I'll be happy to answer them for you. So let's get started. As an overview of the marriage-based green card process, foreign nationals, people from other countries who marry a U.S. citizen, can get a green card or become what is officially known as a lawful permanent resident, or LPR, based on the marriage to their spouse if they meet certain eligibility requirements. They're within a category that's known as immediate relative, or IR. And the reason that that's important is that there's no backlog in that category. Many of the other immigration categories, as you'll see in just a second, have a backlog or delay in the ability of a person to obtain a green card. So thankfully, immediate relatives don't. With that being said, it doesn't mean that the green card is instantaneous. Instead, what it means is that once the immigration service and possibly the consulate or embassy, if someone is overseas, goes through the normal processing, the normal background and security checks, and related processing, that the case will be approved. In contrast to that, if instead of a U.S. citizen, the foreign national marries a person who is a green card holder or lawful permanent resident, there is a backlog in that category. And that's because it's not considered to be an immediate relative. Instead, it's what's known as one of the preference categories. So in this case, it's family-based 2A, and there is always a backlog in this category. So going on a little bit in terms of what is a marriage. So let's start at the beginning. What is a marriage, and what type of marriage would qualify for a green card, whether it's to a U.S. citizen or to a U.S. green card holder? So according to the Immigration Service, the official rule is that a marriage is valid for immigration purposes where the marriage is valid under the law of the jurisdiction in which it was performed. So in other words, if people were married in India or London or Ecuador, as long as the marriage was legal in the place where it was conducted, then the USCIS considers that to be a legal marriage and a fine basis, a legal basis for the green card. Now, with that being said, there are certain types of marriages that the Immigration Service does not consider to be legal for marriage purposes, even if the marriage was legal where it was conducted. And this includes marriages such as polygamous, civil unions or domestic partnerships, or proxy marriages. So again, even if those are valid where they were conducted, the Immigration Service will not recognize them. There's one other type of marriage I wanted to mention that is also not recognized, and that is what's known as common law marriage. Certain places, such as Canada and other places, have a rule that if people live together for a certain amount of time and hold themselves out to be married, that they are considered married for certain legal purposes. In contrast to that, the U.S., and specifically the U.S. Immigration Service, does not recognize common law marriages. This came up once when I had an H-1B worker who wanted to have his spouse cross the border. I said, "That's terrific. Please provide me with a copy of your marriage certificate." He said, "Actually, we don't have a marriage certificate. It's a common law marriage." Unfortunately, again, the U.S. government doesn't recognize that kind of marriage, and because of that, the spouse was not able to enter as an H-4. Now, moving on, same-sex marriages are recognized as long as the marriage was legal and valid in the jurisdiction that it took place. As always, it's the applicants who have the burden of proof to prove that their marriage is legitimate and that it was legitimate where it was conducted. And the last thing, the last point on this slide is a question that I'm often asked. And the question is, people say, look, I was married in India, or I was married in France. I know that I need to register my marriage in the US in order to apply for a green card. The answer is thankfully that there is no registration requirement. And actually, there is no way to register a marriage in the US. I believe what they're kind of referring to is having a court marriage or some type of civil marriage conducted in the US. But as you can see, doing that is really not necessary because as long as the marriage was legitimate where it was done, there's no need to take any steps with respect to the marriage here in the United States. Moving on, marriage to a US citizen versus lawful permanent resident or green card holder. So again, as we discussed a couple of minutes ago, there is a difference in terms of processing time, and immediate relatives are those who are married to a US citizen, whereas those who marry a green card holder are in a preference category, which is, again, family 2 or family 2A. So in terms of immediate relatives, the processing is very straightforward. Again, with LPRs, the process is straightforward. It's just that there will be a delay in the process, a delay in the ability to file the green card application, and also possibly thereafter a delay in the government's ability to approve the green card. This chart is actually taken from the official document published by the US Department of State each month, which is known as the Visa Bulletin. This is the government's official list of the cutoff dates in various categories. So I just wanted to stop here for just a minute. As you can see, family sponsored has 5 categories. There's F1, F2A, F2B, F3, F4. What you don't see on here is immediate relative, and that's because, again, there is no backlog in the immediate relative category. So let's focus on F2A, and that is for spouses of green card holders. So if you look across the line, you'll see a cutoff date, and it's actually very similar. It's the same for all of them except Mexico, and that's just a week earlier. But what this means is, let's say hypothetically, you were born in China, and that's mainland only, not Taiwan. In order to proceed with the green card process based on your marriage to a person holding a green card, only a person whose first step in the process, which we'll talk about in a minute, was filed before February 8th, 2020, can now proceed to the final step of the process and can also get the green card approved. Everybody else has to wait. And as you can see, I mean, just a quick explanation about why certain countries are selected here while others are not. If you starting with the left, it says all chargeability areas except those listed. So that's really the worldwide pot of marriage-based green cards. The other countries that you see, China, which is mainland, India, Mexico, and the Philippines, are listed separately because the government has found that if they were in the worldwide group, the all chargeability group, they would most likely use up more than their fair share of marriage-based green cards. And for that reason, they're separated out and they are allocated separately. Single intent versus dual intent. So let's say that you're here as an H-1B worker or as an F1 student or as a J-1, whether you're a J-1 college student, a J-1 resident physician, or a J-1 researcher. F1, which are student visas, and J-1, which are these resident or college student visas. They can also be used for other folks as well. Those are officially known as single intent visas. And what that means is that the bearer of this visa, the person holding this visa, must have just a singular intent, which is to come to the US temporarily for a specific purpose, and then have the intent to leave. This person is not supposed to have the intent to stay in the US permanently. And in fact, when you apply for and obtain this type of visa, you also have to show that you have strong ties to your home country, family ties, economic ties, etc. Now, in contrast to that are certain visas, a very small number, including the H-1B visa, and those are known as dual intent visas. Now, what dual intent means is that you can actually have the intent to do 2 things at the same time. One is to enter the US on a temporary basis for a temporary purpose. So with the H-1B, it's a work visa. So you intend to enter the US on a temporary basis to work at a temporary job with a specific US employer. At the same time, because it's a dual intent visa, It also allows you to have the intent to immigrate to the US on a permanent basis. So the nice thing about the H-1B is that you can have both intents at the same time, and it will not disqualify you from being able to enter the US on this temporary visas. Now, with that being said, it is of course understood that certain people on F1 visas and J1 visas may want to immigrate at some point. Perhaps they meet someone while they're in the US and they want to get married. So there's not a prohibition on someone with an F1 or J1 getting married to a US citizen and getting a green card. It's just that there are certain things that you have to note and certain requirements that have to be met. For instance, with J1s, as you all know, certain J1s are subject to the 2-year home residency requirement. Not all J1s, but just some, especially those who come to the US for graduate medical training. Those folks are automatically subject to this 2-year rule. So unfortunately, the 2-year rule does get in the way of getting a marriage-based green card. So if you hold a J1 and you are subject to that rule, you have to deal with the 2-year requirement first before you can actually seek a marriage-based green card. So whether that means obtaining a waiver of the J1 2-year requirement, or perhaps returning to your home country for 2 years, either way, once you've dealt with the 2-year requirement, you can then go on and apply for the marriage-based green card. With J1s, as you know, there are many different types of waivers. Depending on the type of J1 you hold, it may be that if you're a physician doing a residency or fellowship, you may need to get a Conrad 30 waiver or a VA waiver, or others that generally involve working for 3 years in a medically underserved area or at a VA hospital. So during those 3 years, you have to be an H-1B, and that would prevent you from pursuing the marriage-based green card process during that time. Now, with that being said, if you're an F1 or a J1 who has fulfilled the 2-year requirement or obtained a waiver, the other thing to note, which is listed at the bottom of this slide, is that in order to leave the country while the green card process is going on, and specifically an application that's known as an I-485 is pending with immigration, and we'll discuss that in just a minute, that you actually cannot leave the country without first obtaining advance parole, or AP. AP is permission to leave the country and return to the US while your I-485 application is pending with the Immigration Service. If you should leave without that, the minute you leave the country, some bad things will happen. The first is your I-485 application will automatically be denied. It's automatic and there's no discretion involved. The second thing is when you try to re-enter the US using your F1 visa stamp, for instance, there is a chance that you'll be not denied entry, because if the officer sees that you were an applicant for a green card, that would right away destroy the intention that you might try to, the intention that you're coming to the US on a temporary basis, or that you're returning to the US to resume your temporary stay as an F1. The fact that you've applied for a green card, even though this I-485 has been denied, is evidence to the officer at the airport or at the border that, you know, maybe you have more than just this single intent to be here temporarily. In fact, you've already taken concrete steps to obtain a green card, and it may cause either a minor headache at the border or a huge headache, and even result in your inability to enter the US. You may be refused entry. So this advanced parole is really just mandatory for people who are on F1, J1. If, in contrast to that, you have an H-1B or some other types of temporary visas, it is possible to leave the US and re-enter using that type of visa, such as an H-1B, without advanced parole. Next, you're married and it's a legitimate marriage. So how do you prove to the Immigration Service that this is a legitimate marriage? And really 2 ways of looking at this. Not only that the marriage was legitimate in terms of it being officially recognized or legal where it took place, whether it took place in Michigan or in Istanbul or London or wherever, but really the Immigration Service is also looking for other types of evidence, and specifically evidence that the marriage is real. And a real marriage, according to the Immigration Service, involves the commingling of assets and liability. So commingling of assets and liability. Let's talk about that for a minute. What does it mean? So the Immigration Service takes the position that if it's a legitimate marriage, like with most marriages, the spouses are going to commingle assets and liabilities. You'll have certain things in both names, and it's not like you'll each continue to live a separate life and you'll simply be legally married. but instead you're going to show that you're doing things together. You're taking on obligations together, financial obligations or other obligations. You're traveling as a couple, and let's say maybe there are pictures or other evidence of certain trips and things. So specifically, what kind of evidence can be presented to the Immigration Service? So on this slide, we've just listed some of them. There are certainly others as well, but evidence of joint bank accounts, joint credit cards, leases or mortgages that are in both names. The same with utility bills, tax returns that have been filed in both names, and other things that you see here. One important note that I wanted to make that I actually did not list on this slide, but is really critically important. Generally, this evidence would be provided to the Immigration Service two different times. First, at the time that the green card application process starts, when you, assuming that you're in the US and you're using the US process, which is known as adjustment of status. Along with the normal application documents, you would want to include evidence such as what's listed here, showing that as two spouses, you're living a shared life, you're commingling assets and liabilities. The other time is at the interview, which we'll talk about in a minute. And at that time, you would also want to present similar evidence. Now, here's the really important thing to note. What you don't want to do is just one day before you file the case with immigration, or let's say a week before you go to the interview, all of a sudden start putting everything in both names. The Immigration Service wants to see a nice track record over time of things in both names. And so if you just do it a day before the interview or a week before you file, there's not going to be that track record. Instead, it's going to look a little questionable, let's say, because it looks like you suddenly start to put everything in both names because you know that's what immigration wants to see, and hence you rush around to put some things in both names so that you have some evidence to provide to the Immigration Service. So what I always recommend is that once you get married and you know you're going to be filing a marriage green card case, to go ahead and start putting everything in both names. This way you have a nice track record, you have a number of weeks or months of bank statements or mortgage statements, et cetera, that are in both names. And this way you can provide this evidence to the Immigration Service, not only at the time of filing, but most importantly at the interview, if there is one. The interview would be several months later, and having with you several months worth of these statements and other evidence would be very helpful in showing the officer that this is something that has been going on for a long time. You have been right along commingling assets and liabilities. Now, with photos of weddings, the wedding and trips taken together, these are really optional, but are definitely helpful. In terms of trips taken together, if you have such photos from trips before the marriage, after the marriage, that's great. You would just want to identify when and where they are. Trips with family members, maybe holiday celebrations, that sort of thing, tend to be very helpful in showing the officer in a very concrete way that this is a legitimate marriage. It wasn't one that was done for purposes of the green card. It was a legitimate, loving, honest marriage, and these photos will bear that out. The last thing that's mentioned is the affidavit of support, and that's actually one of the official forms that's required for all marriage cases, and this would be filled out by the U.S. citizen spouse. It's also sometimes possible, if necessary, to consider the income of the foreign spouse as well, but it's really proof that should the foreign spouse need financial assistance while they're here, that you as the U.S. spouse will provide it, and that this person is not going to seek any type of financial help from the U.S. government or a state government. Green card interview. So as I mentioned a couple minutes ago, the green card interview is critically important. And among other things, this is where the toothbrush question comes in that I mentioned at the outset. So let's talk about the interview for a minute. Traditionally, an interview has always been a mandatory part of the green card process, whether you're doing the green card process in the US, which is via the process known as adjustment of status, or overseas through the process known as consular processing. This is a chance for the officer, either at a local U.S. immigration office or the officer at the U.S. embassy or consulate overseas, to speak to the applicant or applicant and spouse in person and really get a feel for whether this marriage is legitimate. These officers have been doing interviews for a long time, especially if they're very experienced, and they can usually tell within a nanosecond sometimes even before asking the first question, whether this is a legitimate marriage or whether instead this is a fraudulent marriage that was done just for the purpose of obtaining a green card. Again, they have so much experience, they can tell right away. So these green card interviews were absolutely mandatory, and then COVID hit. Now, with COVID, the Immigration Service tried to minimize the number of contacts and interviews that people had with the local offices around the country. And so what they started doing in marriage cases is, as long as there's strong evidence that the marriage is legitimate, and also a feeling like a personal interview would not really add anything to the determination of whether a marriage is legitimate, the Immigration Service on a case-by-case basis has been waiving such interviews. And in fact, waiving most of the interviews, especially the cases that we've handled over the last year or so, we have not had one marriage interview. Every interview has been waived. And among other things, I like to think that's because we file a very, very complete case with all of the evidence that I just mentioned a minute ago, plus a lot of pictures and other things, to try and give the adjudicating officer a really good feeling that this is an honorable and honest marriage. And again, the interview would not serve any real purpose. It would really be a waste of time and effort for everybody. Now, with interviews, and again, the officer can certainly order an interview, whether it's just random or whether there's a particular reason that the officer wants to do an interview. Each office is different. And here's where the toothbrush question comes up. I have done marriage-based green card interviews over the past 30 years in many different offices around the US. Every office does interviews differently. Some offices interview spouses together in the same room or cubicle. Others instead will interview one spouse, ask a list of questions, then ask that spouse to go back into the waiting room, interview the second spouse, ask the same list of questions, and then we'll compare the answers. So the toothbrush question actually came up during one interview that I did in Chicago, where an officer asked each party, each spouse, what was the color of the other person's toothbrush? Another question the officer asked was whether they have a toaster in their kitchen. So as silly as these questions are, and honestly, it's hard to believe that knowing the color of your spouse's toothbrush really has anything to do with the validity of a marriage. But this was the officer's way of trying to find out, are these people really living together? Are they really married and living in the same place? And there were some other questions also. So if there is an interview, the applicant and U.S. citizen spouse really need to be ready to answer a full range of questions about the marriage, and not just the usual ones that are often asked or usually asked, such as how did you meet, where did you meet, where did you get married, have you met your other spouse's parents, have you traveled together, where does your spouse work, that sort of thing. The interview can be wide-ranging. It really depends on the officer and on whether the officer believes that the marriage is legitimate, but I really have seen everything under the sun. Now, the purpose of the interview is really to prove to the officer's satisfaction that this is a marriage of two people who really seem to know each other. Not only do they live together, but they really seem to understand and know things about the other person to the extent that this seems like a legitimate marriage. In contrast to that, during such an interview, if it seems to the officer like, these people claim to live together, they claim to be married, I mean, they're legally married, but they don't really seem to know much about each other. Like, this spouse number one doesn't really know where spouse number two works, or spouse number two has never met any coworkers of spouse number one, has never heard anything about work or related questions like that. That's when the officer starts to really have significant doubts about whether this is a legitimate marriage and whether the green card should be approved. So preparation is really key, and not only being prepared for questions like this, but also being prepared by having all the documentary evidence I just mentioned a couple of minutes ago, and a long track record of that evidence, months of bank statements and months of other statements, just so that you can prove to the officer's satisfaction that there is a real marriage, there is real commingling, and then the green card should be approved. So one last note before moving on. If the foreign spouse that you are seeking to obtain a green card for is outside the US, the final step in the process will be an interview at the U.S. Embassy or consulate in the person's home country. In that case, normally it's just the spouse who goes through the interview. And the interview in that case is mandatory because it's, in addition to making sure that the marriage is legitimate, there are certain other things that the officer at the embassy or consulate has to do, including eventually issuing what's known as an immigrant visa, or for our purposes, the green card, but it's really a visa allowing the person to enter the U.S. and register for their green card upon entry. Next, let's talk about the application steps that are required for adjustment of status. Just a very brief overview. This is for the U.S. process. So this is where the U.S. citizen is in the U.S. and also the foreign citizen is in the U.S. And for that, you use a process that's done entirely in the U.S. It's commonly known as adjustment of status. And that's because one of the main applications, which is the I-485, is officially known as an application to adjust status. So the first step, as always, with every type of immigration procedure or process, is to gather the necessary documentation, necessary information, and then to go ahead and complete the necessary application documents. The I-130 and the I-485 that you see here are the key documents, and there are others, of course, including applications for advanced parole, travel permission, and also an application for a temporary work card, which is called an EAD. But the I-130 and I-485 are the primary applications. And these are filed together in a package with the Immigration Service. Now, if you're a U.S. citizen, there is no backlog. This package can be filed, let's say, one day after you get married or sometime thereafter. If, on the other hand, you're an LPR or have a green card, you can file the I-130, but you cannot file the foreign-born spouse cannot file the I-485 until your place in the backlog becomes current. Of course, going on, there would be, if there is an interview, both spouses would attend. And the green card is usually approved at the interview, if there is one, or shortly thereafter. A number of times when I've been at an interview, the officer thanked everybody for attending and said that he or she would make a decision and then notify us by mail. And when that has happened, usually it's within a day or two, whether it's by regular mail or email, we see that the approval has taken place. In contrast to that, the process for when a foreign-born spouse is outside the country is a little bit different. The same gathering of the information and documents, but the filing process is a bit different because only the I-130 application is filed. That's an application for alien relative. That's filed with the Immigration Service, and once that has been approved by the Immigration Service, it is then possible to move on to the next steps. And the next steps involve what's known as the U.S. National Visa Center, and then the applicable or pertinent U.S. Embassy or consulate abroad. The National Visa Center and the embassies and consulates are part of the U.S. Department of State. So we're really dealing with two different entities here. The I-130 is processed and adjudicated by the USCIS, which is part of the U.S. Department of Homeland Security. They then forward the approval to the U.S. Department of State's National Visa Center, and then eventually it works its way to the pertinent U.S. Embassy or consulate for final processing and interview. Generally speaking, the process is once the I-130 has been approved by Immigration or USCIS, they will forward the approval to the National Visa Center. The National Visa Center will take a number of weeks to log it in. They will then have the applicant pay certain fees and then allow the applicant to fill out what's known as a DS-260. The DS-260 is a very extensive online biographic data form. Once that's completed and also certain supporting documents are uploaded, eventually the National Visa Center will notify the embassy that the case is what they call documentarily complete. And the embassy or consulate will then go ahead and schedule an interview. As it indicates on number 4 here on this slide, part of the interview process is having the foreign-born spouse undergo a medical examination with actually an embassy or consulate-approved physician locally. In other words, if you're going through the U.S. Embassy in Paris, then it would be a local physician in France who has been approved by the embassy for purposes of this immigration medical exam. So it's not as if the person can go to their family doctor and have an exam done. Now, going back just quickly for a second to the adjustment process, and that's the U.S. process, that also requires an immigration medical exam. That exam is done in the U.S. by a USCIS authorized or approved physician. There's many of such physicians all over the US, and it's possible to obtain a list of physicians by going to the Immigration Service website or by calling their 800 number. But for our purposes here, for this consular processing, the foreign processing, usually each embassy has a very, very small handful of physicians who are approved to do these exams. And the normal procedure is that the exam is done within, let's say, 2 to 5 days of the interview that's going to take place. So in other words, let's say your spouse has been scheduled for March 25th for the green card or immigrant visa interview. In that case, the medical exam would normally be done within a week prior to that interview. It could be 5 days, it could be 2 days. It all depends on the embassy procedures. So those physicians who do the exams are very familiar with this. They know that there's a short time period between the medical exam and the interview. And so they're able to do it quickly, get the results quickly, and then the person can go ahead with the already scheduled immigrant visa or green card interview. Now, in terms of what happens after the interview, it's not that the person has a green card approved at the interview. Instead, they get what's known as an immigrant visa. And that is a visa that is put in the passport. It's a full-page sticker, multicolored with a person's picture. It's stuck into the passport. And it's that document that allows the person to enter the US as an intending immigrant and register for the green card when they land here, either at the airport or at a land border point if they're coming through the border. So what happens is, first of all, you have to use it within 6 months. It's not valid indefinitely. So you would need to travel to the US within that 6-month period. And upon entry, whether it's at an airport or a land border point, you'll speak to a US Customs and Border Protection officer. They will then refer you to a secondary officer who will then take some information down, register you for the green card, and admit you into the US. Now, the plastic green card itself may not reach you for anywhere from 1 week to a month or two. In the meantime, the officer will place an entry stamp in your passport, usually next to the immigrant visa stamp or sticker that's already there. The combination of that immigrant visa and also the entry stamp allows you to live in the US permanently while waiting for the green card, and also to seek employment. So in a way, it's sort of like a temporary green card until you actually receive the plastic green card. Now, many years ago, it would take up to a year to receive the plastic green card. However, over the last 10 years or so, we've noted a really wonderful shortening of that time period. Some people receive the green card within a week or so. It just suddenly shows up in the mail one day. And so that has been a terrific improvement by the Immigration Service. Next, let's talk about new marriages versus old marriages. So there is a difference. The Immigration Service looks at marriages the following way. If it's an old marriage or marriage that has been in existence for 2 years or more, the Immigration Service seems to believe that it's probably a real marriage, it's a strong marriage, and for that reason, they're willing to grant the full 10-year green card. Now, in contrast to that, when a marriage is less than 2 years old, the Immigration Service may not have any doubts at all about the validity of the marriage. On the other hand, to make sure, or to try and help to make sure, that this was not a marriage that was done for purposes of getting the green card, they do add an extra step when a marriage is less than 2 years old on the day that the green card is approved. So that extra step happens during the last 90 days of the 2-year period. So what I mean by that is, when a person has a marriage that is less than 2 years old, they do get the green card, but it's only valid for a period of 2 years. During the last 90 days of that 2-year period, the two spouses, the US citizen, the foreign spouse, will need to prepare and file a form that's called an I-751, and also include supporting documentation. The purpose of the 751 and this additional documentation is to show that the marriage is still ongoing, that it's still a valid marriage and legitimate, and that the Immigration Service should then go ahead and grant a permanent green card. Type of evidence that's required is really the same type of evidence that was required initially to get the green card, whether it's bank statements, mortgage statements, other things. In addition, one other type of document that's required at this point would be affidavits, usually from at least 2 people who know you and can attest to the fact that you are living as spouses, that you're holding yourself out to the community and the world at large as spouses. So the affidavits are really more like letters that are signed and sworn to in the presence of a notary public. So there's really no specific format that's required. Instead, it's just at least a couple people vouching for the fact that you are holding yourselves out as a married couple, you're doing things that way, and that this person is willing to vouch for that. So in terms of validity of the green cards, the normal validity period is 10 years. And so if the marriage is more than 2 years old on the date that the green card was approved, the green card will be valid for 10 years. Now, 10 years is not permanent, but yet the green card is permanent. So let me explain what this means. Many years ago, when I was a young lawyer, green cards were approved and they were permanent forever. So even if you got a green card and you were 3 years old, you could literally go through your entire life carrying a green card that had a picture of you when you were 3 years old. So even though you're now 83, your picture is from when you were 3. So when I was a young lawyer, the Immigration Service decided that they actually would like to get an updated photograph of everybody every 10 years. And so they implemented this process whereby everyone with a green card must apply for renewal every 10 years. The good news is that the Immigration Service is not going to re-adjudicate the basis of the green card every 10 years. Instead, it's just an administrative procedure whereby they will review the application, they will obtain a new photo, a digital photo, and then issue a new green card to you. So again, it's not looking at the underlying basis, it's just an administrative procedure so that you carry a green card that at least somewhat looks like you, even though you will hold it for 10 years. One additional note, if you become a US citizen at some point, and we'll discuss that in a couple minutes, when you become a citizen, you will give up your green card. And so this 10-year renewal of the green card will not apply to you any longer. Next, green cards for stepchildren. This question often comes up. And so just very briefly, stepchildren of US citizens are considered to be eligible for the green card just as their parent is. And so that's not a problem at all. They must be under 21 years of age and unmarried in order to get the green card as part of this spousal green card process. If you and your spouse have been married for less than 2 years, then the stepkids will also receive the green card, but will also be valid just for the 2 years until the 751 has been filed and then approved by the Immigration Service. Another question that comes up are cases of divorce or cases where one spouse, where the spouse passes away. Many marriages, unfortunately, end in divorce. And it's not to say that the marriage was not legitimate at the beginning, but at some point after the marriage took place, a legitimate marriage, things happen and the couple splits up and gets divorced. So the question is, if you have a 2-year green card, what happens during those 2 years if the marriage ends through either divorce or by the death of the US citizen spouse? So in either case, you would be required, or the foreign-born spouse would be required to file the I-751 form on his or her own. So normally the 751 in a marriage that's ongoing has to be signed by both spouses. In this case, it would only be signed by one spouse. In addition, there's no need to wait for that 90-day window at the end of the 2-year green card period in order to file the application. Along with the 751, the person would file evidence that I mentioned earlier, bank statements, other things, affidavits, showing that the marriage was legitimate when it was entered into. And that's really the test for this type of situation is, was the marriage legitimate when it was entered into? As long as it was legitimately entered into and unfortunately ended through divorce or the passing of the US citizen, the Immigration Service will generally go ahead and approve the permanent green card. So as long as the marriage was honest and honorable and legitimate at the beginning, the fact that there was later a divorce would not prevent the person who holds the 2-year green card from actually getting the permanent green card and having the ability to stay in the US permanently. And the same goes for those people whose US citizen spouse has passed away. Let's talk for a minute on a related matter about fiancé visas. These are K-1 visas, and sometimes people are engaged to citizens who are foreign citizens who are living outside the country and want to know how that person can enter the US in order to then seek a marriage-based green card. There is a visa that's called a K-1 that would allow such a person to enter the U.S. For purposes of then getting married and also applying for a green card while in the U.S. So two things have to happen once the K-1 person enters the U.S. The person must get married to that specific U.S. citizen who sponsored the K-1, and then they also must file for adjustment of status, the I-485 application you heard about a minute ago, within 90 days of entering the U.S. If those two steps are not taken, the person's K-1 status ends and then they need to leave the U.S. So the K-1 is a good visa for that situation of when a U.S. citizen has a foreign fiance they want to bring in the U.S. But there are some things to note. First of all, they must have met in person within the last 2 years. There are certain situations where the Immigration Service can grant a waiver of that, whether it's based on extreme hardship to the U.S. citizen or based on cultural matters. If there are certain cultures where the spouses are not supposed to personally interact or meet prior to a marriage taking place. But again, as always, with any type of case, you have to prove that the relationship is legitimate. K-1 processing does take a while. Processing really depends on the embassy or consulate that's handling it, but it's not as if it's like an H-1B visa or a J-1 visa where you can simply sign up for an interview and then maybe a week later, a month later, et cetera, get your K-1. It's really beyond the scope of today's talk, but it does require a lot of processing because the government wants to make sure that this really is a fiancé situation, it's a legitimate situation, and that the foreign spouse really is coming here for the purpose of marrying this U.S. citizen and getting a green card based on that, and that it is a legitimate engagement and then will be a legitimate marriage once the person is here in the U.S. I'd also like to talk for a moment about K-3 visas, and I'm going to tell you, don't get one. They're available, and if you look online on the Immigration Service's website, it actually looks like it would be very helpful. But again, my advice, and I can honestly tell you 99% of all immigration lawyers give the same advice. Don't get one. But let's go over it anyway, just for a minute. The K-3 visa is a temporary visa which allows a foreign spouse to enter the U.S. Well, a foreign spouse who's already married to a U.S. citizen to enter the U.S. on a temporary basis while waiting for a green card to be processed and approved. So it sounds like a great idea. I mean, let's say you're a U.S. citizen, you have this foreign spouse that you're married to, and you know green card processing is going to take a while. So the K-3 sounds like a great way to get someone here quickly so that you can live as spouses while doing the green card process. The problem is that the K-3 process involves a number of steps and is very, very slow. And in fact, it's so slow that there's no reason to get one. Instead, the better thing to do is to simply process the green card through the U.S. Embassy, through the State Department and the U.S. Embassy in the foreign country, because for the same processing time, this way the foreign spouse will wind up with an immigrant visa and hence a green card, rather than a K-3. And again, the K-3 is just a temporary visa whose sole purpose is to allow the person to enter the U.S. And then apply for a green card. So rather than going through all of that, better just to process the green card and have the person enter using this immigrant visa. So K-3 is really just for informational purposes. I do like to mention it because if you look at the Immigration Service website or some other websites, it seems like it might be a great alternative and an easy one to pursue, just a couple of applications, some filing fees. But honestly, the process is very cumbersome, very time consuming, and not worth the time and effort. Okay, next, looking ahead to citizenship. The logical question that people have after getting the green card, or maybe as they're thinking about getting the green card, is, well, what happens in the future when I want to become a U.S. citizen? I know that the green card is one pathway to citizenship, but what is the procedure? What is the timeline between these two different things, green card on one hand and citizenship on the other? So with an employment-based green card, or really a green card based on any other basis where a person is not, or where it's not based on marriage to a U.S. citizen, the normal waiting time between getting the green card and being able to apply for citizenship is 5 years. So the 5-year period actually starts the date that the green card is approved. So if you look at your green card, it will say something like permanent resident since. That's the key date. 5 years from that date, you can then be eligible to apply for U.S. citizenship. In contrast to that, the waiting period is only 3 years if you're married to a U.S. citizen, but you have to be married during that entire time. Now, with either of those, the 5-year waiting period or the 3-year waiting period, the good thing is that if you meet all the requirements early, you can actually apply 90 days early. So 3 months before the 5-year period or the 3-year period will be reached. Gives you a chance to get the application filed early and get a head start on having the Immigration Service process your citizenship application. The citizenship application or citizenship, the process is known as naturalization, and that's why you'll see that word in this slide. Naturalization is the official name for the process to become a U.S. citizen. In terms of how long it'll take to become a U.S. citizen, really depends on the current processing time when you apply. There are just certain fluctuations in processing time at the Immigration Service, and so it's really hard to give you a general idea of how long it will take. The good thing is that the naturalization process is very straightforward. They want to make sure that a person is not a criminal, a terrorist, that you haven't broken any laws, that you don't want to overthrow the government, and other things that might not bode well for the U.S. if they were to grant you U.S. citizenship. At the end, there is a mandatory interview at the end of the citizenship process. That interview is not waived. It's a very straightforward interview. Before the interview, you'll want to brush up on your knowledge of U.S. history and U.S. government. Not to go into depth, but there's a list of 100 questions. And so in addition to asking you for biographic information, they will ask you 10 questions on U.S. citizenship and government from the list of 100. And then you will pass. Once you become a citizen, U.S. citizen, that's permanent. And the green card can be permanent too if you choose not to become a citizen. And that's probably an important point I should make at this point. Becoming a U.S. citizen is voluntary. It's not mandatory. Many people choose to remain on the green card forever and never become a U.S. citizen. On the other hand, some people want to become a citizen because it does allow you to vote in the U.S. Also, it's permanent, meaning once you have the U.S. citizenship, it cannot be revoked unless you obtained it through fraud or misrepresentation. It also, of course, allows you to have a U.S. passport. So for these reasons, many people do choose to pursue U.S. citizenship, but once in a while, someone will say, green card is good enough. I'm happy with this, and I don't need anything else, in which case citizenship is not mandatory. It's something that they can choose to do or not to do. I'll see if there are any questions, but before, just kind of a little bit of an advertisement for our next session on March 21st. Visas for new residents and fellows. Because the match, as you know, or if those who are involved in graduate medical education know, the match is next month, I thought it would be timely to have a session on visas for new residents and fellows. And this will be really addressing the various visas, J1s, H1s, and other things also that you may see, such as TPS or people who are in the U.S. as an H4 and have what's known as an EAD, temporary work card. So we hope that you'll join us at that time, and we would be very happy to have you join us as we go over these visas that people will have or obtain so that they can start the residency and fellowship later this summer. So with that being said, let me see if there are any questions. Do we have any questions? Okay, no questions. Well, what I'd like to do, first of all, here is to thank you all very much for joining us today. I hope that the information was helpful. And as always, feel free to reach out to me with questions. I'm always happy to hear from everybody. Let me give you my email address, which is mike@shermanimmigration.com. And so as you can see it here, mike@shermanimmigration.com, also my phone number, and also the website. A video recording of this meeting today will be on the website shortly. So feel free to access it if you want to review any of the information presented. But again, feel free to email me at any time. I'm always happy to answer questions. And with that being said, I would love to see you next month, and hopefully you'll join us at that time. So thank you very much all for joining us today, and appreciate your participation very much, and hope to see you next month. So thank you very much, and have a great rest of the day. Thank you.